Now, this week, the Supreme Court of Appeal set aside the requirement for the rotation of audit firms as enforced by the Independent Regulatory Board for Auditors. The court found that the IRBA does not have the legal authority to adopt and implement the mandatory audit firm rotation. As its founding legislation, the Auditing Profession Act, does not provide it with such powers. COSATU says it has warned Parliament and Treasury repeatedly about the issue, adding that government needs to take action if it intends to win the fight against state capture and corruption. Matthew Parks is COSATU's parliamentary coordinator and joins us for a conversation on this. Matthew, thank you for making time for us. Why do you believe that this judgment by the Supreme Court of Appeals is actually a blow in the fight against corruption and state capture?
Sure. No, thanks for having us. Afternoon to the viewers. No, look, for us, we're quite disappointed as COSATU. We understand the judgment, and it's the kind of anticipation we had warned government and parliament about for 5 years. So basically, the Supreme Court by the Independent Regulatory Board of Auditors, which oversees the auditing sector of the country, they were taken to court by some disgruntled auditors for obvious reasons. On an issue, so on a specific rule they have. So the Independent Regulatory Board of Auditors put in place a very progressive rule which required that companies who have auditing contracts rotate these auditors every 10 years. And they put that there to prevent an unhealthy, financially dependent, often an incestuous relationship between auditors and the companies whose books they should be auditing, making sure are clean, etc., above board. So the Supreme Court of Appeal said that IRBA didn't have the legal powers to institute such a rule requiring the rotation of auditing companies every 10 years, because there's no provision for that in the law which governs IRBA, the Auditing Profession Act. So that's quite disappointing, because if an auditing company can have a relationship with one company for 10, 20, 30 years, they're going to develop a financial dependency upon that company. These are large auditing contracts, and they're going to make sure that they keep that company happy, they don't rock the boat, they don't expose corruption or malfeasance, and that's going to undermine the very objective of having auditors. And workers, the economy, society at large are seeing the consequence of auditors, at best case scenario, turn a blind eye to corruption, to illegal activities. And I think we saw in many SOEs, many companies, public and private, where auditors were actually complicit. They actually helped cover up corruption. Yeah. They whitewashed it. They said their auditing reports are above board, etc. Yet we saw during the Zondo Commission that many of the auditors were complicit. So the ruling the judgment scrapping this ruling is a blow. But we think it can be fixed, but it requires the Auditing Profession Act to be amended by Parliament.
Yeah, but how soon can it be fixed? Is it not too late to amend the Auditing Profession Amendment Act with 6 months left in the parliamentary calendar before the 2024 elections? And when can Treasury draft and prepare that Auditing Profession Amendment Bill that will provide the IRBA that legislative authority to reinstate this MAFR?
Yeah, so you're right, it's too late now. We have 11 months until the elections, but in the parliamentary calendar, we've got about 6 months left. So you're not going to be able to draft a bill, take it to cabinet, to public comments, to parliament, both houses of parliament, etc., within 6 months. It's physically not possible, nor is it constitutionally possible. So that's quite disappointing, obviously. But Treasury can begin the work on it now. They can go and draft a bill, and it'll be quite a simple bill. You're just simply providing for a simple additional power to be given to IRBA. They can do that over the course of this year, do the necessary consultation with the public, with cabinet, etc. Then when the 7th Parliament is elected next year and is sworn into office around April, May next year, they should then have that bill ready to be tabled to Parliament immediately. So the Parliament, at least the new Parliament, could process it over the course of the second half of next year, and then pass it into law by the end of next year. So it is a year and a half vacuum, which is unfortunate, but it can be fixed. But we need Treasury to move with speed, because we had raised this thing with Parliament in 2018, 2019 with the previous amendment bill. We had raised it with Parliament again in 2020 and 2021. And Treasury said we're being alarmist, there's no need to worry. It can be provided for in the regulations. Parliament, unfortunately, also did not take the matter seriously enough. And as a consequence, this was easily predictable, and we're now in this crisis.
So chief financial officers, Matthew, hold sway in the decision to appoint an audit firm, but they themselves are drawn from a limited pool of auditors, often from the same auditing firm. Doesn't that complicate things?
We think there's sufficient space, and we think that we have significant, some large auditing companies, quite a few of them. There's a sufficient, pool of auditors to choose from. And yes, you could say, for example, if you have a company in Springbok or Victoria West, small town, you might struggle. But, auditing firms are quite large companies. They've got a national footprint, so there is space to do it. And also, you're not saying they must be rotated every year, which might be, logistically cumbersome. They're saying it every 10 years, once a decade. So we've got, at least about 4 or 5 very large international auditing firms based in South Africa. We have many local auditing firms. So there is space. You're not doing it every year. You're doing it every decade. But it's for a valid reason. It's going to benefit those companies, those workplaces, to make sure the books are legit. There's no, legal activities, corruption, criminal activities taking place. It's going to benefit the shareholders who invest their money, the pension funds in these companies. It's going to benefit the fiscus too. They know that we're preventing corruption. We're making sure these companies, be public or private, are well run. There's no hanky-panky taking place. But we've seen a consequence. If you don't do it, look at many of our SOEs. Eskom is in trouble today, which has been audited, Transnet too. We've seen even private companies like Tonga Hewlett being in the headlines for the wrong reasons previously. And again, that came down to poor auditing. So this is critical to rotate this very sensitive profession to prevent illegal activities taking place.
Okay. Matthew Parks, COSATU's Parliamentary Coordinator, thank you for making time.